And the Court of Appeal looked very carefully at the grounds of complaint that had been put forward by the lawyers and decided that despite the High Court's decision that it would not be unlawful, that it would be lawful to send asylum seekers to Rwanda, that in actual fact doing so would breach the European Convention on Human Rights under Article 3, which is the prohibition on inhuman, degrading treatment and punishment and torture. So where this leaves us now is with a decision that makes it very clear that these kinds of transfers to Rwanda for the purpose of processing their asylum claims and according to the memorandum that the UK government concluded with Rwanda, also offering them a place to stay if they were found to be refugees, that scheme as it stands is unlawful under human rights law. I think immediate next steps for the UK government will be clearly to consider whether or not it's going to appeal that judgment. It has the possibility of lodging grounds of appeal to appeal up to the Supreme Court, which is the highest court in the United Kingdom. And there again, it might well put forward challenges as to the approach taken by the Court of Appeal and in effect ask for the High Court's decision to be reinstated. Given this decision in the Court of Appeal today, which strongly suggests or finds that removals to Rwanda would be in breach of our international obligations and, of course, our incorporated domestic human rights law obligations, that I think leaves the government in a rather difficult position as to how to progress with the illegal migration bill. Now, I say this because the key plank of the illegal migration bill is that asylum seekers will be removed to Rwanda to have their asylum claims processed and again to be given refugee status there if they're found to be refugees. Without the ability to do so lawfully, it's difficult to see what any of the provisions of the bill could continue to have effect. The finding that a country which does not have robust asylum procedures, which does not have an independent judiciary that's able to ensure the rule of law, has much wider implications for these kinds of schemes. It suggests, I think, that whether we're talking about the UK or other European countries, that they will not be able to send asylum seekers for third country processing to other countries where those asylum procedures and judicial guarantees are not properly observed, as was found today in this case. I think that's a real problem because the UK certainly over the last 20 years has been having conversations with a number of governments of other countries. And so far, as I'm aware, it's only Rwanda, after knocking on many, many doors all around the world, that has come back to say yes. And I think it's quite likely, based on this experience, that any country that might wish to enter into this kind of memorandum with the UK government, as Rwanda did, would equally be quite likely to be a government which had weak asylum procedures. There were questions about safety in the country and so on. And I make this point because the UK, I think, has had negotiations with many countries which do have robust court structures and asylum procedures, and there's very little willingness there to contemplate these sorts of schemes. So I think that the judgment actually does send a ripple effect more widely through this idea of sending asylum seekers to third countries, whether that's the UK trying to do it or other countries in Europe.